Okay, welcome everyone. Thank you for joining us today, and this is another in our line of, I think, really engaging and important alumni speaker series that we have here at the law school. And today, this is one that I think is a little bit different than a lot of these talks, where we're focusing on the Flint water crisis, and more specifically, a case, some litigation involved here with all the attorneys present up here on the, I guess not really on the stage, but at the front of the room, we'll be talking about their involvement specifically in the Flint water crisis. And maybe through this we can have a little bit of discussion about the history and how we got to this point. And then I'll try and direct some questions. But my role here today is really to just welcome our guests and to welcome you all here for joining us. We do have an hour, so we'll have about 25 minutes to a half hour of discussion for our panelists, and then we'll open it up to questions, and hopefully we can get a really good dialogue going. And I know that that's, I think, what our panelists are hoping to have here today. So just by way of some brief introductions, Nick Schroeck, I direct our Transnational Environmental Law Clinic here at the law school, and together with Noah Hall, we both teach environmental law and some other environmental programs here at the law school. Going back several years, we've had some involvement in the Flint issue, all the way back to 2009 when we commented on this proposal to create this Caringundy Water Authority. And so we've been following this and tracking it for quite some time. Our clinic students this semester are working on a couple different research projects related to Flint. So it's, I know, very topical and exciting for us to have our guests here today to learn more. So first I will introduce Bill Goodman. So Bill here to my left. Bill is and I'll do just quick introductions, and I'm sorry I don't have Peggy and Iman in the bio, so we'll have to just do this on the fly. But Bill, many of you know, because Bill's an adjunct professor here at Wayne State, where he teaches civil rights law, past president of the National Lawyers Guild, graduate of University of Chicago, both with his Bachelor of Arts and Juris Doctorate degrees, practices law at his firm Goodman and Hurwitz. They represent families and individuals in a variety of cases, police misconduct, government misconduct, which I think is maybe an issue here in the Flint discussion, dozens and dozens of cases against the United States and other entities, as well as he represented the Detroit City Council as a special counsel in the struggle over the removal of Mayor Kilpatrick. So a lot of history doing this type of litigation. And then also to my left is Iman, who's an attorney who's assisting with the case, and so maybe I'll have you just give a brief introduction when your time is to talk there. To my right, Michael Pitt. Michael is our featured alum speaker here today, proud alum here of Wayne State University Law School, and founding member of Pitt, McGehee, Palmer Rivers PC. And Michael's handled many different types of complex litigation over the years. Group actions, class actions, multiple party cases, and I think we'll hear more today about the class action and what goes into creating a class in a complicated situation like we have here in Flint. You may have read Michael's work on the Neal case, where he's part of a group of civil rights lawyers working on this case involving 18 women prisoners in Michigan who were raped and sexually assaulted by prison guards in Michigan's prisons. Worked on that case and received a lot of well-deserved recognition for his efforts there. And he's also worked very closely with our distinguished jurist in residence, Justice Kelly, and working on her task force to think about the way that we elect our Supreme Court justices in Michigan, and if maybe there's a better way to move forward in that process. And then, of course, to Michael's right is Peggy Pitt, and she's also involved in the case. And again, I apologize for not having a bio, so hopefully we can have a little bit of introduction as you begin your remarks. So with that, I think the way our agenda is set up is that I'm to turn it over to Bill first. So what I'll do is I will quiet down and we can hear from our distinguished panelists about a little bit of history with Flint and then what's going on with their case. Thank you, Bill.
What do you think, about 5 to 10? Something?
That'd be perfect. Yeah, I think we do that about each person, and then we'll go to questions.
Well, good afternoon, everybody. It's an honor to be here. Even though I did go to the University of Chicago, as Nick said, I was at Wayne for a year, so I consider myself a Wayne alumnus as well. And I teach here, so it's close to my heart. Anyway, Flint. Part of what we are working very closely as a team on this. Our firm, Peggy's firm, Treshelle Young, who's in Flint, and Deb LaBelle, who's in Ann Arbor. What I've focused on a great deal, and I just spoke to Professor Ackerman's class earlier this morning about this, is the constitutional rights that were involved and that were violated as a result of the decisions that were made in Flint. And when you start and work your way through, I think there's a clear case to be made for what's called a state-created danger. That is that these various government officials, the emergency managers working hand in glove with the governor, and really, we believe, at the direction of the governor and the governor's office, the Michigan Department of Environmental Quality, again working hand in glove with the governor, and who were reined in my opinion, by many of the acts of the governor, the Michigan Department of Health and Human Services, and other public officials were all responsible for inflicting harm on a very discrete group of people, that is the residents of the city of Flint and the users of Flint city water, harming those people without any valid governmental purpose to do so other than to save a few bucks, and arguably that may have been an invalid, or that may have been an empty rationalization and excuse as well, because as it turns out, they may have saved nothing, or at most very little. Harming people, then learning very quickly that there was a problem, discounting the complaints of the people who lived in that city. You don't count, you're just troublemakers, you're the people who raise trouble, raise hell. We're going to ignore you. When they walked into the public meetings with bottles of water that they were pulling out of their tap that smelled foul, that tasted foul, and that looked disgusting. And they said, oh, go ahead and drink it, relax, no problem. So that was further, underlined the harm that these public officials not only initially inflicted, but continued to inflict. They not only caused the harm, they increased the risk of continued harm by telling people, relax, forget it, don't worry about it. And this happened over and over and over again. As they tested, they got results that were alarming. And they were told, retest, don't pay any attention to the most seriously contaminated homes with the worst results. We won't make them a part of our next test results. And when we test, we're going to test in a way that's going to minimize the lead levels in the water by letting the taps run for half an hour before you bring the bottles in to have them tested. And they still were bad. The results were bad. And the public officials were saying, oh, the results are fine, you can drink this water, no problem at all. Ignore any alarms you're hearing. And then, when independent investigators came to the fore, they took these independent investigators and they tried to discount them. They tried to make them look bad. They attacked them. Initially, that was their instinct. In other words, the instinct was do harm, cover up that harm, lie about it, and conceal. That's what the constitutional tort is. It's a violation of, in our opinion, the due process clause, and it was inexcusable. It met all the tests, and in Professor Ackerman's case, I talked about one leading case, which is Ackerman, which is, pardon me, Colstrom versus City of Columbus. And then just briefly, we are seriously looking at also a violation of equal protection based on race discrimination. We have a city that has been weakening for years as a result of all sorts of attacks on the role of government in helping people, and especially in helping working people, poor people. And then this city is targeted, it's predominantly African Americans, targeted for emergency managership, which means the emergency manager tells the people of the city, don't pay any attention to, we're not going to pay any attention to what you people say. We're going to make the decisions ourselves based upon bean counting. And if it hurts you, too bad. That's a anti-democratic decision which has been imposed in the state of Michigan. 52% of African-American people in the state have lived under emergency managers. And what percentage of Caucasian people have? 2%. So, and anyway, there's the whole emergency managership, and then there's the infliction of the harm, which was targeted on African-American people in the city of Flint. Then if you look at the way in which it was targeted, the neighborhoods which were most endangered, and people who were most injured, it is in those neighborhoods which are overwhelmingly African-American within that city. And on and on and on. And then the comments that were made about the people who were complaining, the people who were told to relax, please don't get all upset. If it had happened in Birmingham, if it had happened in Grosse Pointe, we all know the reaction would have been different. So that's a brief outline of some of the constitutional issues in the case. Thank you very much.
So let me address the litigation strategy, because in order to get a successful outcome for our clients, and the multitudes of them, you have to have a good litigation strategy. And so one of our main legal obstacles is governmental immunity and sovereign immunity. So Michigan is one of the leaders in governmental immunity around this country. And the laws are on the books as written, and the laws on the books as interpreted by the Michigan Supreme Court have given government officials the maximum amount of protection against lawsuits. So how do we as litigators get around that? So the first case that we filed was in federal court. And if we were right about the constitutional tort, and I think this is the perfect state-created danger case, I don't think you'll find a better set of facts for that. We still are going to have to, there is no governmental immunity for the state and municipal actors in their individual capacities. They could be held accountable for a violation of the Constitution in their individual capacities. And for the city of Flint, we have to show a violation of a custom and practice or a policy of constitutional violations. So we overcome tort immunity by going to federal court. But you all know there's an 11th Amendment immunity, which protects the state of Michigan, just the state of Michigan. So we can't sue the state of Michigan for financial remuneration. You can get what is called prospective injunctive relief against the state, but you can't get the state to pay you money in federal court. The actors that we've sued, the city and the state actors in federal court, have what is called qualified immunity. And if they do make a qualified immunity motion, that could stall the case, because there's an automatic right to appeal a denial of a qualified immunity motion. And what does that do to the case? It stops it dead. So we want to keep the train moving. How do we do that? Well, we filed two other cases, one in Genesee County Circuit Court on January 19th, and another one in the Michigan Court of Claims on January 15th. If the federal case gets stalled because of a qualified immunity motion, we still have our Genesee County Circuit Court case. And the guts of the Genesee County Circuit Court case is that we sued lower level officials who don't have full immunity. The Michigan Government Immunity Statute has two tiers of immunity. The top tier for the governor, elected officials, and the heads of departments is absolute immunity. Cannot be sued for tort damages so long as they're performing a governmental function. The lower level is if the lower level employee, like the employees who work at MDEQ, not Mr. Wyan, who's a director, because he's got absolute immunity, but Mr. Bush and Mr. Cook and Mr. Prisby and all the other defendants in our case, if these individuals are grossly negligent, they can be held liable for the harm that they cause. And you may have saw in the paper 2 days ago, the Attorney General has now cut those defendants loose, those individual Michigan Department of Environmental Quality defendants. They've been told, get your own lawyers, because they now claim there's a potential conflict of interest between these defendants. The governor and the MDEQ employees have a conflict of interest. I thought the governor said he was going to accept responsibility. The buck stops with me, but he apparently not. He's now saying that the state's not going to be responsible for what they did, for their mistakes, and that's gracious, to call them mistakes. The state now says that we're not going to be held responsible. So they're setting up a very dangerous situation for themselves. I mean, I think it's a form of suicide, frankly, for them to start pointing fingers at each other, but that's what they're doing. And now we have a court of claims case, and that's a claim under the Michigan Constitution. You can only sue the state of Michigan for money damages in the court of claims, not the individual actors or employees, but the state itself. So that's where we are in the court of claims. And so yesterday we filed a motion in the court of claims because when we filed the case on January 15, it was originally assigned to Judge Mark Boonstra. A few days later, what? Richard? Is it Richard? Judge? Mark? It's Mark. Okay. So, Mark Boonstra had the case, according to the docket sheet, and we got the papers back from the court, and had the name Chief Judge Michael Talbot on it. So how did this happen? So we called the Court of Claims and said, how come we had Mark Boonstra and now we have Judge Talbot? And we were told that Judge Talbot himself assigned the case to himself. That he had issued some sort of administrative order in December that allowed the Chief Judge to reassign cases. So he, on his own, decided to reassign the case to himself. There are certain criteria that's in the administrative order, none of which apply to this case. And so, what is the reason for the blind draw, folks, right? It's supposed to take politics out of the judicial system. It's a way that we, as citizens, know that when you file a case, it's going to get assigned blind draw. Friend or foe, Republican, Democrat, young, old, black, white, makes no difference, it goes into the blind draw. When you have judges that are manipulating the system, for whatever reason, it creates what? The appearance, at least the appearance of impropriety. And is that a violation of the judicial canon of ethics? Absolutely. A judge shall not do anything that creates even the appearance of impropriety. And we think it stinks, and we have filed a motion to have it undone, and we shall see how this plays out. So that's the litigation strategy that we're undertaking. Yesterday, we served 11 subpoenas. We served the governor, we served the MDEQ, we served the Michigan Department of Health and Human Services. We sued like 3 or 4 engineering companies that was supposedly giving advice to the city of Flint and MDEQ. We sued the Detroit Water and Sewage Department. We sued the treasurer. Who else did we serve? We served everybody. We're gonna get it all, okay? The public demands, our clients demand to know what the heck is going on. And so we're gonna get, March 1st is the return date on the subpoenas. Hopefully by March 1st, we're gonna have more information about what exactly happened. And we used the Genesee County case to send the subpoenas out, because in the federal court case, that's kind of stalled now, and you don't have a right to immediate discovery in federal court anymore. You can't, when you file your case, you gotta wait and wait and wait and wait before you get discovery. That's just the way the establishment wants us plaintiffs' lawyers to kind of cool our jets. In state court, it's as soon as you file your case, you issue your subpoenas. And that's what we've done. And they can't stop us. We're moving. The train is moving. And to the AG's credit, you know, they've already said they're going to they say they're going to cooperate in terms of producing the information. Well, we'll see how that comes out. But so stay tuned. I'm going to have Peggy talk about the people. Peggy and I have been spending the last 2 days in Flint talking to many people on the ground, you know, what this has meant to the people on this. So you should hear a little bit about it, because you see the newspaper, you see Melissa Mays, our client, she's out there with a bullhorn, and you see Leanne Walters, a brilliant woman who's a whistleblower, and that's about all you see from the people. But we're starting to talk to the people, the average everyday victim, and Peggy's going to share that. And then Iman is going to talk about how you can help us help the city people of Flint.
Actually, I just want to say that you heard something that I've never heard before. You actually heard Michael almost give credit to this particular Attorney General. So you heard it first here today. I'm not going to completely talk about what Michael said I'm going to talk about. He's talked about the procedure in filing all the different lawsuits. I would like to speak a little bit to the damage picture, because there's something else in this case that, as potential lawyers, is really interesting. These are civil cases that we filed, and so, you know, we're asking for a civil remedy, which probably, I will say, is our civil justice system is possibly one of the best civil justice systems in the world. But the only thing that you can really get is an imperfect form of justice. You really can't get complete justice because this injury has happened. The people in Flint, the children in Flint, they've been damaged, and there's no way to go back and really remedy that damage. So often the civil justice system gives you a money remedy. And in this case, that would be such an imperfect form of justice. And it also takes a long time. And in this case, that also is an imperfect form of justice, because people need a remedy now. And the children immediately need services in the schools. They need access to the food, that they probably can't afford. People need pipes fixed immediately. And so the best that you can get working through the system is imperfect. So we really are asking for, and we're hoping that somebody will step forward and they will set up a fund. And this fund will be there now, this fund will be there in the future, and this fund will allow damages and allow people to access this fund as the damage appears. These are children who may, hopefully they're not harmed, hopefully it will never appear, but it may appear 2 years down the road, it may appear 5 years down the road, it may appear 20 years down the road. And so we would hope that there would be something there where they can access it into the future. And this is not a unique form of remedy. It has been done in the BP case. It's been done after Hurricane Katrina. It's been done where they've had a special master come in, often Kenneth Feinberg, and he allocates from this fund. what people actually need when they need it. And if ever there was a case that needed that type of a remedy, this is that case. And so again, that's something that, we would hope would happen. I will speak a little bit to the people that we've spoken to because, in fact, I spoke to somebody yesterday and, as a mother, just listening to her talking about these things that could happen in the future, there is a harm there emotionally that I suppose I could empathize with her to some extent, but not completely. She just spoke about her children and what part of their future, will be damaged, what could they have been that they won't be. And this is a story that you hear over and over again as you start talking to people. What have my kids lost? What potential has been damaged? And it's really it's heartbreaking to hear this. Another woman that I spoke to, just a charming woman who worked so hard to buy a house and paid off the house in 12 years, and she said, I knew that I had a wonderful place for my kids to live, and this house is worth nothing. It's worth nothing at this point in time. And again, the property values in Flint, and she understood that even that in her neighborhood from the point that she bought this house, the property values had fallen, but now they've bottomed out. And so these are property claims, but they are property claims that I think are different than many that we've seen in the past. They are human stories, but they are, I think, of a different kind and a different magnitude than many other civil cases that you see. And it really, and how the people that we've spoken to are persevering through this and carrying on through this and managing to get up every day and move forward with their lives and their kids' lives in whatever way they can, it's humbling. It really was, and I suppose will continue to be a very humbling experience. There is a strength that has been amazing as we've talked to these people and talked to the citizens of Flint. They are they are walking around, though, in spite of the strength, in kind of a haze and gloom that also was disheartening. And again, Iman is going to talk about what you can do to help, because the magnitude of this case also is just astonishing. And we need help in order to help the people that have used the Flint water and been poisoned and had their properties destroyed, and in some cases even businesses destroyed. And that's what I will say now.
Before Iman, I just want to add something Peggy said. It really is shocking to be with these people. And I spoke with a woman yesterday, and a lovely woman, and she lives in what I call a hothouse. Hothouse is we know there's lead there. They measured the lead in her water on January 19, 2016. It was 138 parts per billion. The cutoff for danger is 15. She's like 10 times over. Okay, this was 2 weeks ago, right? And so her house probably for the last 2 years has been shedding this lead. So I asked her to list all the children that, I'm sorry, but all the children that lived at her house the last 2 years, her whole family lives within like 2 blocks of her. I mean, she's got like 30 nieces, nephews, and grandchildren, little kids, that come to her house. She's been feeding them this water for 2 years. She gave me a list. There are 30 children's names on that list who's been poisoned at grandma's house. Shocking.
So my name is Iman Abdulrazzak, and just as for background, I graduated from the University of Michigan in 2012. I was an AmeriCorps attorney doing low-income housing in Western Massachusetts, and then I came back and clerked for the Honorable Denise Page Hood, and now I'm working on the Flint water contamination case. I'm a project attorney, so that's all I do. It's becoming 24/7. We think about it as we wake up and as we go to sleep, and it's kind of consumed our lives. So at this point, I'm managing the volunteer efforts and people who want to get involved with this case, and I highly recommend you do. It's a very high-profile case. We're reading about it in international news. I have relatives overseas in the Middle East that ask me if my water is okay. I was born and raised in Flint, and I still live in Genesee County, and I have family members who've been impacted by this, and we have relatives who are going through very serious situations overseas who ask us a question that we shouldn't be dealing with in a first world country. And so this is your chance, and I think a lot of us go into law school hoping we can do these types of cases. You know, we go in with this attitude of we want to help the underprivileged and we want to help the underserved. And so I think this is your opportunity, and I think it'll get your foot in the door with people who are already doing great work and who've dedicated a substantial percentage of their lives to doing these types of cases. And I also think it'll help distinguish yourself as well. This is a case that is not going away. It's going to be an issue for a very long time. Like Peggy said, some of these kids might be talking about their injuries in 20 years. They might be dealing with this for the next decade. And so when you work on this case, even if you decide that it's not something you, after graduating from law school, that you are going to do all the time, but just knowing that you were a part of it and you contributed to it, I think will set you apart from everyone else who's out there. And it's meaningful work. Everyone used to ask when I go for job interviews, what are you looking to do? I'm looking to do meaningful work. This is the definition of meaningful work. I talk to these people all day, to the people of Flint who are dealing with having lead poisoning with their children, with themselves, and they have very extreme symptoms. And the symptoms that are being highlighted in the papers are not the most serious ones. People are dying. I had a woman make that connection while I was talking to her on the phone. I said, ma'am, when did your husband start experiencing those symptoms? And she's like, let me think about that for a minute. I said, April 2014 was when that began. That's exactly when the water switched. He passed away. Yesterday I was speaking to a father who said his son passed out on Thanksgiving Day. He stopped breathing in the family room. They had to resuscitate him. He's alive now. But these are just some of the examples. And the volunteers are going to have a heavy hand in helping us move this case forward, because those individuals on the other end of the line, they want to hear a voice that cares. And even though we've collected their information and we have a database with these households, we're actually now looking at over 2,100 households that have already signed up. Today, right now, I actually have volunteers that I gave them their assignments this morning. They're in the process of calling every one of those households to tell them, we got your info, you are going to be a part of this case, and we are also going to meet with them on February 16th. So we're getting in touch with them. And I think the next step is we also have to start working more on teasing out exactly what those symptoms are and talking more in depth with every single household. And so there may be some more administrative tasks with some of the volunteers that might involve putting in addresses or putting in phone numbers and collecting the voicemails and the questionnaires and those sorts of things. But those are not insignificant, because those set the stage for being able to follow up with those clients. And I do want the volunteers to be involved also with the interviewing process. It's not just going to be data input. And so I'm hoping that we can get your help. I received a list of volunteers, I think 2 days ago. I've already called up most of them, and we have people coming in tomorrow that we just signed on. So I'm hoping that if you're available in the very, very near future, like I'm talking about next week or next month, sign on, and we really could use your help. It's all hands on deck. We can use any help we can get. And to sign up, go to the website flintwaterclassaction.com. Again, that's flintwaterclassaction.com. And on that website, you'll actually see a summary of the cases that have been filed, of the progress that we've made. And at the very top, there's a volunteer sign-up link. You can go there, it'll take you to a form, fill out your information, fill out your availability, and I will most likely be in touch with you very, very soon after that. And if you can also distribute that link or notify other classmates that maybe were unable to attend, people that might be interested, please do distribute that link as well. And I'll be here, I'm going to be staying afterwards for a little bit, so if anyone has any questions about the type of work that you're going to be doing, do let me know. Thank you for coming today.
One more thing about the volunteer opportunity. It's not just an opportunity to help the people who have been harmed by Flint water. It really is a learning experience that's remarkable, because I think that Bill and Michael would agree that one of the hardest skills to learn as an attorney is interviewing people. And it really takes years, but this would be a wonderful place to start, to learn how to get somebody to discuss what is important, how to discuss something that is a terribly emotional issue, but to discuss it in a factual way, to know when somebody is not saying what they want to say and to help them say it. Just as a future attorney, I think it just would be an amazing learning experience, and you should keep that in mind as well.
Thank you, and thanks to all our panelists. Let's give another quick round of applause. This is great. We do have some time for questions, and I'm sure there are many. And so I would ask that you please limit your questions to questions. I know a lot of people have a lot to say on this, but in the interest of time and with our great panel of experts, we'd like to limit it to questions. So if you have comments, please feel free to talk to us afterwards, but we would like to limit it to questions. And as chair, I guess I'll take prerogative and ask the first question, and I'm not sure if Bill or Michael would be best to answer this, but one thing we didn't hear a lot about yet is emergency manager. And I know a lot of people have questions about maybe immunity with emergency managers. How does that play, and what, if any, impact does the ongoing challenge to the emergency manager law itself, what impact might that have on this case moving forward?
So Bill will talk about what's going on in the emergency manager litigation, but the emergency manager law gives, remember I said there's 2 levels of immunity? So what does the emergency manager get? Top, right? Oh. And when you sue the emergency manager, who has to pay the judgment? The city, not the state. I mean, this is a rape of the cities, and it's terrible law. So, Bill, tell us why it's going to go down.
Well, a lawsuit has been filed challenging the constitutionality of the emergency manager law, Public Act 436, and the challenge is based on a series of constitutional claims. It denies what's called the Republican form of government, that's a small r, everybody, and is an attack on democracy, denies people the right to the right to vote. It's a due process violation, and there's an equal protection claim as well. And there's a claim that's been brought under the 13th Amendment, which is that the emergency manager law, because as I said, disparately impacts African American communities, constitutes what's called a badge and vestige of slavery. And I think that's undeniable. You know, these people can't vote, or if they vote, their vote is meaningless. What the hell? What does that mean? That means that this is a recurrence of the kinds of implications that were wrought by American slavery, enslavement, I should say.
Okay, and so now we'll start with questions, please.
So when you talk about the emergency manager, is there the possibility to link some of the relief to the Flint situation, to repealing the emergency manager law?
I don't know no. I think that what it would do is it would say that the appointment of the emergency manager in and of itself is an unconstitutional act, and add to the liability and responsibility heaped on state government, the state of Michigan, the governor, one hopes, and others. In that way, it might increase or help prove liability, but it doesn't change, it doesn't correct what's already happened. And I might add that the emergency managers, not only the people of Flint do have to pay, but they also are insured, we hope, we believe.
But nothing is gonna correct what happened, so I guess to your point, none of the remedies. So is that one of the reliefs that you can ask for in the claim at all?
No.
Okay.
Well, you know, do I think that the emergency manager law is politically dead? I would hope so. I hope that this has opened up so many eyes that this governor is going to be loath to appoint another emergency manager anytime soon, because he's been so damaged politically by what this happened, and most people are now getting it, that what happened here is tied intricately to the emergency manager law. And, you know, I was watching the congressional hearings yesterday, and, you know, the Republicans are getting on the bandwagon on this deal. And, you know, and so Snyder's political capital is dwindling very, very fast, and he may not have the political ability to use the emergency manager law. One would hope that this is an example of what's going to happen, you know, when government officials mess up big time, they're going to get voted out of office. Now, is this going to affect the whole Republican regime in the state of Michigan? It remains to be seen. I don't think the Flint story is coming off the headlines for a while yet. And as long as these people are suffering and there are people out there advocating for them, it's going to be headlines. And it's going to be on the headlines on November of 2016 when the nation goes to vote again. It could have an effect. It could have an effect.
Yes, ma'am, please.
Do you have any health reports to add to your claims or for your litigation regarding the physical effects of the people who've been damaged, and also the health reports of the people of the man who died and the other young man who almost died?
The question is, do we have medical records substantiating? Not yet. I mean, we're still in the process. We're just getting into the case, and so I haven't even laid eyes on any particular plaintiff's medical records yet, because we just sent out for them. And there are some physicians in the Flint, Genesee County region who are sympathetic, and we're hearing that there are some physicians that are very standoffish. They don't want to get involved, and they're kind of downplaying what's happening. And as I'm going through the interviews, I'm asking people to tell me about their physician, but have you talked to your physician about the cause and effect here? And I'm beginning to learn who the good guys are and maybe who not so good guys are. it's starting to, we're seeing patterns. Certain doctors are showing up over and over again, and some are very encouraging, some are not so encouraging.
And bear in mind, I mean, this is, years, right? You have potentially years of exposure, maybe even continued exposure. And so I think it'll be an ongoing process to try and track down who is potentially exposed and to what levels of contaminants. Yeah?
I have a question about the Court of Claims case. When you said that the judge reassigned the case and he can do that, but what was the motive? Can you articulate that?
This is an impact situation without giving the proof that's in.
I mean, can you argue a higher expertise?
Well, look at, I don't know. I don't know what the motive was. I could tell you about Judge Talbot, a very conservative Republican, and I'll leave it at that.
Probably close to the governor.
Okay, other questions? Yes, please, Professor Ackerman.
Is the challenge to the emergency manager law a facial challenge, or is it an as-applied challenge in light of the disproportionate use of the emergency manager in majority-minority communities?
It's a facial challenge, and it also challenges in terms of the 13th and 14th Amendment aspects of it. That's raised in the complaint, and because that requires further playing out, especially the equal protection stuff. Judge Stee, who dismissed all of the other claims, has allowed that claim to continue, but through a whole variety of procedural quirks, the 14th Amendment claim was dismissed without prejudice, and the whole thing is now on appeal in the Sixth Circuit. So it's a facial challenge, and there's, anyway, yeah, the answer is yes to both.
I would think the equal protection challenge would be largely an as-applied challenge.
That's right, of course, that's right. No question about it. Yeah.
Next question. I know you have them, but please, we'll go another one if.
Let me just say one other thing about the case against the emergency manager law itself. I think that case is sort of what we were talking about before, is tremendously strengthened by what's happened in Flint. That is a huge, it has to be on everybody's mind, including the judges that decide this case, showing how denial of democratic rights really hurts people.
Please.
The outbreak of Legionnaires' disease in Flint and the deaths of 10 people resulting from that, will you be connecting that to the water? And then is there the possibility for criminal pursuit?
There's no question that it's connected to the water. That's already been determined, at least by McLaren Hospital, which is deeply ingrained or involved in the whole situation. I don't know about the criminal stuff, I can't comment on it. I mean, that's right, there's at least 10 deaths. And there were other deaths that were mentioned. Iman mentioned one situation and there could be many more. But those cases are clearly related to the decision to switch to the Flint River. So, I don't know if that helps.
Here,
I think in response, Jeffrey Piker has just filed for that Legionnaires case, and he's connecting it to the Flint water crisis. That was on the news, I think, 2 days ago. But my question is, so psychological damages cannot be quantified, it's just not possible, and the residents of Flint have been traumatized, like this is a genocide. And it's been going on for so many years. In the law, we're told where there's a right, there is a remedy. If these individuals are going to be impacted for the rest of their lives, how do you bring that puzzle piece into the litigation with these obstacles that are in your way, with judges, choosing that they're going to take the case because of their background, their friendship with Governor Snyder? Like, how do you overcome those obstacles, but still say, look, this is a huge puzzle piece because, you can't turn back time.
Well, one of the ways is a jury trial. And if you can get to a jury trial, and the federal court case will provide a right to a jury trial. The Genesee County case will provide a right to a jury trial. The Court of Claims case is no right to a jury trial under the Court of Claims Act. So the hypothetical thing you learn in law school, that there's no wrong without a remedy, that's very hypothetical. After 42 years of practicing law, you learn how hypothetical that is. But it's a great hypothetical, it's a great goal, it's a wonderful objective, and sometimes you see it. Sometimes you see it in a jury verdict, sometimes you see it in somebody in a deposition breaking down and confessing, or sometimes you see it in a judge making a courageous ruling in a case. You see it from time to time. And in this case, I don't know where we're going to see it. I think we're going to see it. It may be years down the road, but there's going to be some form of justice in this. And as lawyers, all you can do is keep moving forward and do the best you can. Keep everybody unified. We have a class action. There are competing class actions that are now forming. Okay, I think we're the mothership right now. We've been there the longest. I think we're the most organized. I think we're the best attorneys, and we certainly have a great team that we've assembled. And some of the Johnny-come-latelys, mainly from out of state, who are kind of hovering around this case and filing really kind of garbage complaints in court and making a little bit of noise. They don't have the organization that we have. But it's through hard work, organization, luck. Luck plays a big role in all of this. And then you get the justice. And as Peggy says, she says it's imperfect. I say justice in America comes in fractions, sometimes very, very small fractions. And I tell my clients, don't hope for multiples of justice, be thankful for fractions of justice. And usually what that means is money damages, which at the end of the day is really a symbol of retribution, a symbol of recognition that you've been harmed, because money is not going to heal in any shape, manner, or form what has happened here. Replacing the pipes, that's a good remedy. Getting money damages for emotional distress, that's a good symbol, and it will help people deal with what they're dealing with, but it's not as good as changing the pipes, believe me. Get those pipes changed.
Let me mention one other compounding factor that's going to play out over the years, and that is the factor of violence. How many people are aware of the relationship between violence and criminal activity and exposure to lead? This goes on, and people should know this, that 10 years down the line, 20 years down the line, you'll see spikes in criminal activity and violence in imprisonment for people who are now children in Flint because of exposure to lead. And how does the system take that into account and work with that? That's a horrible question that we have to figure out something. You have to figure it out.
Okay, so we're coming up on time. We have time for one more question. Matt Clark, and I should say, former clinic student who worked on water affordability plans for drinking water years before the water shut-off crisis, and that's actually gotten a lot of play in city council recently. So, sorry, commercial for the clinic and for you, Matt.
Appreciate it. The crisis has been going on for way too long. So, in any event, my question is for Bill Goodman. You mentioned the 13th Amendment as it relates to emergency management as a vestige of slavery. Is there any jurisprudence following the formal abolition of American-style chattel slavery where the 13th Amendment is applied to any...
Jones versus Mayer is a good place to start. United States Supreme Court case that talks about that and how that plays out. And I think that was a housing discrimination case. Does anybody know it better than I do? But that's a good start, okay? And then call me, I'll give you the other cases I have to brief. That's what I can remember right now.
Okay, well, thank you all so much for your attention. Let's give our panelists another round of applause. Flintwater class action, flintwaterclassaction.com, to sign up to volunteer and to get more information about the case. And I think some of them at least will be able to stick around for a little bit and talk to you after as well. So thank you very much for attending today.